International Commercial Mediation 2019, Challenges and Opportunities. In Italy, there is a proverb, a thin agreement is better than a fat sentence. After the Second World War, international trade boomed, and the related disputes increased as well. International arbitration has been the most widely used means of out-of-court dispute resolution because of its flexibility, confidentiality, neutrality, the preference by lawyers, and, above all, because of its international enforceability, thanks to the 1958 New York Convention and to the more than 150 countries that have undersigned it. But a cheaper and faster commercial international ADR is going its way. It is mediation. Its average cost is less than 5% of the actual cost of an arbitration, and it usually lasts no longer than 2-3 months. And in a short while, it will have teeth. International enforceability, thanks to the Singapore Mediation Convention to be signed in August 2019. Nevertheless, mediation is not the panacea of the dispute resolutions. There are 3 main ways to solve the conflicts: litigation, arbitration, mediation. It's necessary to choose the most adequate one according to the different situations. If the parties live in countries where there are enforcement difficulties, a local court decision could be the best choice. If it is necessary to interpret standard rules, which will be included in future contracts, an arbitration award would be the second best. If time is money and the long-term, well-established trade relationship has to be continued, mediation could be the only way to go. And different issues have to be considered in order to get an efficient cross-border mediation. Mediation contact clauses, proceedings, cultural differences, training. Mediation contact clauses, proceedings, cultural differences, training. Mediation clauses. When drafting a contract, all parties are focused towards the success of the new project, but potential future disputes must be taken into account, and not only the competent court should be specified, but a clause should be included providing, before bringing the matter to the court, for mediation. And if mediation fails, arbitration. Med, then ARB. At the international level, the mediation or arbitration only clauses are well known, but multi-step hybrid clauses are more widespread. The main problem behind the hybrid clauses is whether the mediator and the arbitrator should be 2 different professionals, or, to save time, there can be the same person. According to my opinion, the first solution to different professionals is the best, to allow mediation to have the maximum effectiveness thanks to one of its main features, confidentiality. How to induce international traders and investors to include mediation arbitration clauses in as many contracts as possible? Through the banks. In the Belt and Road Initiative, the great majority of investors resort to funding by the Asian Infrastructure Investment Bank and the Shanghai-based New Development Bank. These 2 institutions could insert multi-step clauses in their financing contracts and could ask, as a requirement to grant a loan, that similar clauses be included in all the contracts signed by the beneficiaries inside the BRI project. The use of mediation was spread greatly. Proceeding. It's better to undergo a procedure managed by a freelance professional or by a mediation institution. If the conflicting parties are familiar with and particularly trust a specific mediator, they can turn to that professional. Otherwise, the choice of a mediation provider with published regulations, tested proceedings, and fees established in advance is recommended. This choice can increase confidence in mediation, especially if conflicting parties belong to different countries and cultures. And what is better, a proceeding managed by a single mediator or by 2 or 3 co-mediators? We answer this question a bit later. Culture-sensitive mediation. According to Sun Tzu's Art of War, in the practical art of war, the best thing of all is to take the enemy's country whole and intact. To shatter and destroy, it is not so good. To fight and conquer in all your battle is not supreme excellence. Supreme excellence consists in breaking the enemy's resistance without fighting. On the contrary, according to 2 Italian scholars, Cosi Giovanni and Romualdi Giuliana, the Western modern war, as it has been formed in before Christ's Greek time, seemed all focused on the direct confrontation of battles on the phalanx, in which 2 bodies of evenly armed hoplites deployed in compact ranks, advancing each other without the possibility of diversion or escape. There is probably more than a simple analogy between the way in which the phalanxes clashed on the battlefield and the way the logi, confronted within the palace, structure the archetypal shapes of Western thought. The war agon finds an equivalent in the way in which the speech in the tragedy, in the assembly, in the court is articulated. That is theatrical, political, or judicial. It's always a debate where the ranks of opposing topics are addressed directly and closely in order to reach a decision. In Western tradition, the clash of interests is usually brought to court. In Chinese, however, the accommodation is mainly used. Scholars underline the differences between individualistic and collectivistic cultures. In individualistic societies, in the present times, mainly Western countries, based on the values of democracy, all human beings are both free and equal in dignity and rights. Therefore, the single person is very important, and freedom, self-expression, personal achievements, protection of the individual in front of the authority are guaranteed values. Competition is stimulated, and the conflicts that follow are handled according to the same rules for everyone. Collectivistic societies, on the contrary, underline the importance of the community, family, clan, caste. The social organization is rigid. The interests of the community prevail over those of the individual. Controversies should be avoided because they would undermine the harmony of the community, and if they occur, they're not handled with written rules and formal documents, but respecting the principle of tradition and group authority. So, the individual can also step back, provided the group's respectability and harmony are preserved. Social norms are structured to prevent internal conflicts, and conflict management is indirect, principally through non-verbal, a little contradictory communication. When you deal with other people, there are two basic principles to be respected. Be yourself, reciprocity. Furthermore, it's also necessary to take account of the culture of the people you are dealing with. Culture have the set of customs, traditions, values, religious principles, rules they have received very often unknowingly from the society, the community, or the group they belong to. All very important matters in mediation, where communication and empathy are basic elements. And co-mediation could be the best way to handle the proceeding with parties with different cultures. Co-mediation offers the parties two communication channels that interact, adding value to the cultural knowledge and mediation skills of the single mediator. The participation of a mediator of their own culture makes the parties feel comfortable and at ease, leads them to opening up and trusting the proceedings. But to be effective, the co-mediators need similar training, deep common knowledge of the proceeding, and shared experience. Training. Geopolitical situation is rather confused. There are strong disagreements on international trade relations. Worrying climate changes will have strong consequences on the international trade lines. For example, new maritime trade routes in the Arctic region. The Belt and Road Initiative will reshuffle not only transport corridors, but also the global division of labor. Artificial intelligence will deeply affect the way of producing in different geographical areas. The use of technology will increase. International commercial mediation will have to deal with blockchain as smart contracts. New challenges, but the other side of the coin, opportunities. If we shall be able to manage the situation. That means, first and foremost, studying and training. The more complicated are the problems, the simpler and more flexible the methods for managing them must be. And the mediation is perfectly suited to this target, but it must be understood, learned, used. The popularity of mediation is growing, but too many professionals have shifted from arbitration to mediation, which has become more adversarial, less interest-based, and more right-based, a trend to be avoided. And an ad hoc training course carried out by universities, trade and financial organizations, and ADR providers located in different countries should be particularly useful. Life is real simple, but we insist on making it complicated.